Okay, so we will continue now to explore the concept of sovereignty, and now to the forgotten roots of the concept. We have here Professor David Dyzenhaus, and he will speak for 25 minutes, and then Professor Roy Kreitner will comment. David Dyzenhaus is a professor of law and philosophy at the University of Toronto and a fellow of the Royal Society of Canada. He has taught in South Africa, England, Canada, Singapore, New Zealand, Hungary, and the US. His area of expertise are administrative law, comparative constitutional law, legal theory, national security law, and political philosophy. Professor Dyzenhaus is the author of, among other, Hard Cases in Weak Legal Systems, South Africa Law in the Perspective of Legal Philosophy, Judging the Judges, Judging Ourselves, True Reconciliation and the Apartheid Legal Order, and Legality and Legitimacy, Karl Schmitt, Hans Kelsen, and Hermann Heller in Weimar, which all of the three of them will be also our heroes for today's session. And then Professor Roy Kreitner will comment. Professor Kreitner is a professor of law at the Tel Aviv University, Faculty of Law. His research areas are private law theory, contract, legal history, and the history and theory of money. He is the author of Calculating Promises, the Emergence of Modern American Contract Doctrine, and he awarded the 2007 Cromwell Book Prize by the American Society for Legal History for this book. He recently worked on the article called A Political Economy of Money, first coming in the Handbook on Political Economy and Law, and the article Responses to Crisis, Refiguring the Monetary and the Physical in the Great Depression, first coming in Money in the Western legal tradition. So, Professor Dyzenhaus, please.
Thank you very much, and thank you very much for having me at this conference. It's a long time since I was in Israel, and I'm delighted to be back. So the title of my paper is Kelsen, Heller, and Schmitt, Paradigms of Sovereignty Thought. And the paper is part of an exercise in retrieval of the thought of Hermann Heller on sovereignty and legality. And I'm sure most of you won't have heard of Hermann Heller. He was one of the main figures in Weimar-era public law debates, but he's hardly known today even inside of Germany. And this is largely, in my view, because he died in 1933, aged 42. And I do think, although I haven't yet got round to demonstrating this, that perhaps Heller provides an answer to Eyal's threshold question, and that is, can one reconcile sovereignty with obligations? In fact, it seems to me to be a strange question, because I think that perhaps if one looks back, and there are historians here, and I'm not an historian, at the history of sovereignty, the idea of absolute sovereignty was never understood to be absolute in the way that we understand absolute today. And if one looks back over history, I think it's quite clear that those who first constructed our idea of sovereignty probably did not have that much trouble with reconciling the idea of sovereignty with the idea of some kind of obligation, even if it were just the obligation to provide peace and security to those who are subject to the power of the sovereign. Now, I haven't yet done the work to show why Heller's position is fully relevant both to international law and to the theme of sovereignty as trusteeship for humanity. Heller did not himself write much on international law, but his assistant, who made his way to the United States of America, did write a Heller-influenced book on international law shortly after his arrival in the United States of America. And I was delighted to find a reference to this book in Mira Siegelberg's paper. There are many delightful things about this paper, but I'm afraid this thing delighted me more than anything else, just because one rarely sees references to this body of work. And Mira, in her paper, says of Gerhard Niemeyer that he was a conservative political philosopher and German emigre to the United States, and she describes his position in this way. According to Niemeyer, the sense of a common legal framework shared by many international legal scholars and internationalists before World War I had depended upon the prior solidarity created by participation in common spiritual community with shared values. The war had shattered faith in this community and thus destroyed the basis upon which the new radical conceptions of international legal order had depended. Now, this wasn't, in fact, Heller's position, and I need to reread Niemeyer to check whether it was his position. But at least in 1942, at the time he wrote this book, I know that he was still a committed social democrat. Only later did he become a minor icon on the American right. And I think he probably would also have not been all that happy, I'm afraid, Mira, with your description of his position. But you might well be right about him. But I dwell on this issue only to make the following point, that I think Carl Schmitt clearly held the view that you attribute to Niemeyer. And there is some reason for supposing that both Heller and Niemeyer at times approached the same view. Why? Because Heller did think that we do need shared substantive values in order to sustain a common legal framework. He did think that these values invoke political commitments, and he did also think that there has to be some institution capable of making a final decision about these values. This, Heller thought with Schmitt, is of the essence of sovereignty. And I was pleased to see that Evan joins the Schmittian position here. If you look on page 15 of his paper, he says that constitutional pluralism is tested because it brings to the fore the issue, who decides. Schmitt couldn't have said it better. Well, I think it is an important issue for all people who think about public law and legal theory. But while Heller does approach Schmitt in the respects I just mentioned, he does share something significant with Kelsen as well. And this is the view that sovereignty is an artificial construct and that the construction of sovereignty is a legal one. Sovereignty is legally constituted and comes always with a claim to legitimacy. It's not a natural concept that can be reduced to power. It's a concept that's created by human beings. The creation is a legal creation, and it always does come with a claim to legitimacy, so one can't disentangle sovereignty from legitimacy talk. I suspect, although this is unexplored in the paper, that Heller might have shared one more thing with Schmitt, and that is the suspicion of, some suspicion at least, of the idea of humanity as residing in international law. He might have thought with Schmitt that this makes international law into something that provides a pretext for humanitarian intervention, big power politics disguised as something else. And there are real concerns here, as I think we'll see later this afternoon when we get round to Andrew Fitzmaurice's paper. But the idea that sovereignty, or government according to law, serves a principle of humanity is central to Heller's thought in one way. For him, the shared values that underpin legal order are not Schmitt's idea of substantive homogeneity, but rather, first of all, values of legality, including a commitment to formal equality, secondly, a commitment to democratic decision-making, and thirdly, a commitment to social equality. But the commitment to democratic decision-making and the commitment to social equality are entailed by the commitment to legality. And this marks, I think, an important difference between Kelsen and Heller, because Kelsen was also deeply committed to democracy, deeply committed to social equality, but he was unwilling to make either of these commitments part of his concept of law. And perhaps, though both Kelsen and Heller would have hated this idea, the best way to understand Heller is as putting forward a political, natural law version of Kelsen's account of legal order and legality. And adapting a great line from Kelsen, I think what one could say of Heller is that who lifts the veil of positive law will not find, as Kelsen said, the Gorgon head of power staring at him, but principles of legality that constitute and condition a certain kind of power, that is sovereign power, power that travels with a certain kind of legitimacy over those subject to it. And the idea of legitimacy over those subject to it, I think, is an important idea within Heller's thought. Because although Heller is a committed Democrat, he was very interested in the idea of the relationship between sovereignty and legal subject, where legal subject is someone who is subject to sovereign power, not necessarily a citizen. And Heller thought that this relationship was a relationship which had to be understood in moral terms, so that when the sovereign acted legally against someone at the border, as Kevin might say, there the sovereign had to act in a way that was legitimate, even though the person against whom the sovereign was acting had no role in consenting to that sovereign's authority. Now, why is this the case? So here I want to pick up on a distinction in the paper that we just heard, the paper by Sergio Della Valle. So Sergio, at the beginning of his paper, makes a distinction which then travels through the paper between ascending and descending concepts of sovereignty. And Hobbes you characterize as putting forward an ascending view. Now, Heller, and I think Heller thought this was true of Hobbes as well, thought that one had to combine both ascending and descending in one theory. One needs the consent of the subjects, so therefore one has the ascending theory, but the consent holds only as long as the power of the sovereign is exercised in accordance with principles of legality, which Hobbes would have called laws of nature. So this is the descending part. So one needs both of these aspects before one has legitimacy. And here I think one might start to get some kind of a connection to international law. Because if one sees that behind the veil of the positive law are principles of legality or laws of nature, if you prefer to call them that, and that the sovereign, in order to act in accordance with law, has to act in accordance with the rule of law, that is, to act in accordance with the principles of the rule of law, one can then stretch things, I think, just a little bit further and find the same sorts of principles as instantiated in international law, perhaps better instantiated in international law than elsewhere, because it might be easier to see these principles when we're looking at the horizontal relationships between states rather than at the vertical relationship between subject and state. Now, when the sovereign governs otherwise, that is, fails to govern in accordance with these principles of legality, and just to give you one example of such a principle of legality, I can revert to the principle that Eyal mentioned right at the beginning of this paper, that everyone whose interests are going to be affected by a decision should be given a hearing before that decision is made. It's that kind of principle that I have in mind. When the sovereign fails to govern in accordance with such principles, then we reach a kind of limit case. That is, we have to ask the question whether that sovereign has ceased to be sovereign. And in this limited sense, I think one can start to understand the sovereign as a guardian or trustee, because the sovereign is constituted by law. Constitution by law is not merely constitution in terms of the positive law, it's also constitution in terms of the principles of legality. And when the sovereign's positive law can't be reconciled with the commitment to the principles of legality, then we're entitled to say, whoever the we is, that the sovereign has acted unlawfully or stepped outside the limits of his power, acted ultra vires, to use the term that administrative lawyers are fond of. Heller, unlike Kelsen, did not think that it was the case that sovereignty disappeared into law. He wanted to preserve the idea that the sovereign can decide against the positive law. And this is why, as I mentioned earlier, he remained preoccupied in his work with the Schmittian idea that the sovereign can decide against law. But when Heller thought about the sovereign deciding against law, he very much thought of the sovereign deciding against positive law for the sake of the principles of legality. So somewhere in the legal order, there has to be an institution capable of taking that kind of decision. Why is this important, perhaps, in this debate about sovereignty as a trustee for humanity in international law? Well, I think, and I've done nothing yet to develop this idea, but it's an idea that I've had for a few years, actually I think since the two of us participated in a seminar at NYU years ago, just after the Cardi decision came out, that we might be able to construct a middle position between the two standard positions in international law. So either you have monism or dualism. And the middle position that I've thought about, although I'm not sure whether much can be done with this, is something that I call messy monism. And what is messy monism? Well, messy monism tells one that one tries to make sense of the domestic legal order and the international legal order without presupposing that these are dual orders, but one doesn't collapse either one into the other. Rather, one has to see that the values travel in both directions, from both domestic law to international law and from international law to domestic law. And what makes these two orders not dualistic is that what constitutes them as legal orders is in part the principles of legality that I think we can make an argument for exist in any legal order. And so it should be no surprise that in a situation of, let's call it, conflict between the Security Council and the European Union, where the Security Council is putting people on lists as security risks in a way that has severe consequences for those people, that we find, I think it's the European Court of Justice, right, making a decision which pushes back against the Security Council and in a way awakens the Security Council to its obligations under international law, including its obligations to core principles of legality, like the principle that everyone should get a fair hearing before a decision is taken that affects his important interests. And it might be the case that if we're looking for the institutions that can enforce those sorts of norms, we're going to find that both domestic courts and I don't know whether we could call them quasi-international courts like the European Court of Justice or the European Court of Human Rights are going to be the institutions that, as the present international order exists, that will be making those decisions. But in order to preserve the idea of sovereignty, I think we have to have an institution that is capable of making those kinds of decisions. We can't have the domestic order somehow subsumed into the international order without the institutions that are capable of making what both Heller and Schmitt consider to be a sovereign decision. And that's where I'll end. Thank you.